Welcome, everyone. Can you all hear me okay? I've been having some technical issues.
Yes, we can, Hannah. Good morning, good afternoon, everybody.
Hello, everyone.
Good afternoon.
I apologize for keeping you in the waiting room for a few moments, but I promise we have a great program today with our friends at Mason Hayes in Ireland. So with that, I'm going to go ahead and hand it over to our EMEA co-chair for the group, Philip.
Thank you very much, Anna. So welcome to everybody. I think it's too late to wish a good new year. At least in Switzerland, we say it's okay until the 15th, and today it's the 17th, but I will break the rule and nevertheless wish all the best for the good new year. And we will have today first a presentation by Rory and his colleague, Nomal, who will present Ireland, tell us about enforcement of decisions, court decisions and awards in Ireland. Afterwards, Ryan will present us the Miller-Martin dispute resolution team. And we also are interested in your proposals, ideas for upcoming events of our group, and last but not least, we hope to have also some time to discuss a bit among us and to introduce each other, in particular people who attend for the first time. So let's get started with Rory and Donald, and the floor is yours.
Great, thank you very much, Philippe, and good afternoon or good morning or good evening, everybody. Myself and Donald Brannock, who's joining also, are here in Dublin. We're going to spend the next 20 to 30 minutes, closer to 20, I hope, speaking to you just in terms of an overview on the arbitration market and legal setup in Ireland, and then also issues relating to enforcement of judgments in Ireland, both within the EU regime and judgments of courts outside the EU regime. Donald's going to talk to that once I give you a whistle-stop tour through the arbitration situation in Ireland. And just starting on that, with a brief look backwards, the principal arbitration legislation in Ireland for 60 years was the Arbitration Act 1954. That was almost a precise copy of the English Arbitration Act of 1950, which is one of the foundation stones, really, perhaps, of international arbitration law in the common law market. And many of the common law jurisdictions have very much adopted the English 1950 model, or had until relatively recently. Some of the key features of that piece of legislation were principally that the arbitrator didn't have the ability to determine his or her own jurisdiction. So there's a fundamental restriction in the 1954 Irish setup that was not relaxed until 2010, and I'll kind of move along to that momentarily. But the old legislation had significant room for intervention and review by the courts, and the ability within the legislation for the courts to extend the time for the commencement of arbitration. So in effect, override arbitrators on issues like time limits. And that all stemmed from really the early to mid 20th century approach to arbitration, where the courts were inherently suspicious of arbitrators. Moving forward by about 50 years, England changed its position in 1996 with a new arbitration law, and Ireland changed its position in 2010 with a new arbitration law. And the two systems have very significantly diverged in those pieces of legislation. The English approach very much is a growth out of the 1950 Act, with significant powers retained by the courts to review arbitrators, to hear effectively appeals from arbitration, and so on. So there's still quite a lot of court intervention in the English system. The Irish Act in 2010 moved completely away from the English system and adopted the UNCITRAL model law. So Ireland from 2010 is an UNCITRAL model law system, and that involves, as many of you will know from your own jurisdictions, very limited review by the courts. Ireland signed the New York Convention, 1958 New York Convention on the recognition and enforcement of arbitration awards, and did so very early, I think in the 1970s, if not before. And the 4 grounds for review within the 1958 New York Convention, in terms of illegality, public policy, failure to follow proper procedures, and other grounds for resisting enforcement, they're reflected in the 2010 piece of legislation and in the UNCITRAL model law. Arbitrators have the ability to determine their own jurisdiction. So the competence principle is placed at the heart of the legislation, and that can be reviewed in the High Court, which is the principal court of first instance, but only once, as it were. There can be a review of a decision on the assumption of jurisdiction by an arbitrator or the rejection of jurisdiction, but the review in the High Court cannot be appealed. So that's really the end of the matter, and it happens very quickly. And so that is really, as far as jurisdictional intervention goes, very, very limited ability to review anything to do with the substance of the arbitral proceeding outside of the New York Convention grounds. So it's very much squarely aligned with New York Convention, UNCITRAL model law, and that has been the enacted for both international and domestic arbitration in Ireland since 2010. There are a couple of small variations with respect to domestic arbitrations, but nothing of any particular significance. The law is very similar for international and domestic. And then moving on to really, what's the experience of arbitrating under that act? What is the attitude of the courts? And until very recently, the attitude has been very significant deference to arbitrators. And there has been a consistent adoption of what you might call international norms with respect to review of arbitral awards within the New York Convention grounds, and particularly any challenges to jurisdiction. The courts are very reluctant to review an arbitrator's determined that they do have jurisdiction, and the courts are generally very deferential to arbitrators' decisions. And the policy position is obviously that if parties have contractually agreed to use arbitration as their method of resolving disputes, then the courts will enforce it. And where that might be slightly scrutinized further is where there is no formal written arbitral agreement, and the arbitral agreement is incorporated perhaps by reference or by exchange of contractual documentation, and you have to say the battle of the forms with the dispute as to whether or not an agreement to arbitrate has been formed. Those type of matters will receive a reasonable degree of scrutiny, but again, there needs to be very strong grounds to resist a reference to arbitration and an attempt to stay court proceedings to arbitration. If there is a review of the arbitrator's jurisdiction, decision on jurisdiction, that review is a full review. So it's not simply a review of the decision as to whether or not it meets the legal threshold. It is a complete rehearing of the matter in substance, where the court will investigate the jurisdictional question on its own, regardless of the decision of the arbitrator or the arbitral tribunal. Recently, as many of you will know, practicing arbitration, there has been a reasonably significant amount of scrutiny on whether preconditions to arbitration in contracts are in fact preconditions to a tribunal having jurisdiction. And the approach generally, as we looking across a number of jurisdictions, is that courts are reluctant defined contractual provisions to operate as preconditions to an arbitrator's jurisdiction. There's one decision in the Irish courts in recent years, which in fact does not align with that approach, where the court found, as a matter of fact, that the failure by the referring party to comply with preconditions to arbitration, that failure deprived the arbitrators of jurisdiction. And that's a significant deviation from international norms, particularly within the, what you might call the UNCITRAL family. The English courts have firmly taken the view that failure to comply with preconditions does not deprive the arbitrators of jurisdiction. It may amount to an admissibility issue, and whereby that the arbitrators do have jurisdiction, but if the dispute has not gone through pre-arbitral requirements under a contract, it may in fact not be admissible at that time before the arbitral tribunal. And you may ask yourselves, well, what's that all about then? What's the significance of what's the distinction between admissibility and jurisdiction? Is it not really the same thing? Well, it is fundamentally different, because admissibility is not reviewable under the New York Convention or the UNCITRAL model law, and only jurisdiction is. So what the courts are doing internationally is taking this issue of contractual precondition compliance outside the New York Convention, outside the international enforcement mechanism, but by interpreting it as an admissibility issue which can be cured. So there's a decision from the Irish courts that I think will be reviewed, and I think it will be brought back into what you might call conformity with international norms on that question. And then turning to other issues that are perhaps of interest to the group, we have a lacuna or a gap in the approach to arbitration, particularly international arbitration in Ireland. Is at the moment, third-party funding is not lawful for arbitration, international or domestic arbitration in the Irish market. The Irish courts have closely followed and applied the very old common law relating to champerty and unlawful funding of litigation, and they don't like it. They see it as being illegal, and that also applies obviously to arbitration. So there is an amendment coming forward to the Irish Arbitration Act, which will make third-party funding lawful within the realm of international arbitration. The intention is for third-party funding not to be available or to be lawful within domestic arbitration, but certainly within international arbitration. And that amendment to legislation is expected early this year. Another interesting development that's attracted some note, I think, internationally, is the approach of Ireland to arbitral provisions, dispute resolution provisions within investor-state agreements. And this is obviously a topic of significant interest within the EU and also elsewhere. Ireland is a signatory to the Washington Convention, and the EU trade agreement with Canada has been the subject of a constitutional challenge in the Irish courts, which has actually succeeded in respect of the dispute provisions. And so that is the arbitral provision within the EU-Canada trade agreement. And that has been found to be unconstitutional by the Irish Supreme Court in what is a very complex decision. There are 7 judgments of the court, pretty much all of them looking at different aspects of the issue, but the consensus, what the common law is called the ratio decidendi, the actual point on which the agreement, the decision is binding, is that the arbitral provisions within the trade agreement are not compliant with Irish constitutional law with respect to dispute resolution, because there must be scrutiny of the arbitrators before the courts. And the type of scrutiny they have in mind is the scrutiny that comes within the realm of the New York Convention. So the very limited scrutiny under the New York Convention the court is effectively saying that level of scrutiny must be available for any arbitral decisions under bilateral or multilateral trade agreements. And they have indicated that the constitutional problem can be solved with an amendment to the relevant 2010 Arbitration Act, which will allow for equivalent level of court scrutiny on the 4 bases of challenging an award under the New York Convention. So it's not a very high bar, and it is something that will have to be legislated for in Ireland in order to bring things back into conformity with our EU partners. And then beyond that, really, what is the popularity of arbitration in the Irish market? And within various sectors, it is very active, and particularly infrastructure, construction, major projects, major investments. Arbitration is a recognized way of dealing with things, and a very popular way of dealing with things. In financial services, less so. There tends to be a preference for court in a lot of sectors. And within the aviation industry, Ireland is very significant a seat of business, but not yet a very significant seat of arbitral references. It's expected that will grow. So there's a busy arbitration market in Ireland, and one of the features that has perhaps influenced it a little bit is Brexit and the United Kingdom coming out of the EU and out of the Brussels regulations and the EU enforcement regime. Even though that has nothing really to do with arbitration, it still sets a tone that there are questions as to why people will have London as a seat of arbitration. But really, one of the most significant reasons people will look at in terms of London is the role of the courts. For some people, that is a significant attraction, that they have the ability to bring disputes within certain parameters within the court system and have judicial scrutiny over disputes. For many other practitioners, they do not want that scrutiny. They want an untrial model law approach, which has the limitations of the New York Convention at the heart of any judicial review of the tribunal or the decision. And look, I'll stop there. I'm conscious of just keeping an eye on time, and Donal now is going to speak about enforcement of judgments. And what we might do is just allow Donal to conclude his segment on enforcement, and then we can come back and take any questions collectively on either the arbitral section or the enforcement of judgment section.
Okay, thanks, Rory. Yeah, so as Rory said, I'm going to speak just a little bit on the enforcement of foreign court judgments under Irish law, both from a European perspective and a non-European perspective. So obviously, Ireland being an EU member state, if you're looking to enforce a judgment from an EU member state, you'll be looking at the Brussels recast regulation. The Lugano Convention, obviously, as well, applies if you're enforcing a judgment from a European free trade area state. And obviously, many of the European colleagues on the call will be familiar with the principles that apply under Brussels and Lugano. But otherwise, you can bring an application under Irish common law for recognition and enforcement of a foreign judgment, and there is no requirement that there is a bilateral treaty or convention in place if you want to seek enforcement of a foreign judgment. But there are well-established common law principles that the courts will apply. Probably one of the key differences if you're looking to enforce under the Irish common law principles versus enforcing under Brussels or Lugano is that when you're enforcing under Brussels and Lugano, effectively recognition and enforcement is automatic, provided obviously all of the relevant conditions under the regulation of the convention apply, and then a party needs to bring an application obviously to have recognition or enforcement refused under the regulation of the convention, whereas at common law effectively you need to bring an action on the foreign judgment, which can then be resisted by the debtor. So I guess there's a heavier lift in terms of trying to enforce a foreign judgment under Irish common law principles than there are under the Brussels regulation or the Lugano Convention. In terms of enforcement and recognition being refused under Brussels or Lugano, again, many of you will be familiar with the principles that apply there. Obviously, enforcement can be refused if it's manifestly contrary to public policy, where the judgment was given in default of appearance, if the defendant wasn't served in sufficient time or wasn't allowed to defend the claim, unless they failed to challenge it, or if the judgment obviously is irreconcilable with the judgment given between the same parties in the relevant member state, or irreconcilable with an earlier judgment given in another member state or a third state involving the same cause of action and between the same parties, and if that judgment is recognizable and enforceable under the relevant principles in the Brussels regulation and Lugano. And obviously, if the judgment conflicts with the jurisdiction rules in Brussels or Lugano, and the court that gave judgment didn't have jurisdiction to give the judgment under the regulation or the convention, then enforcement may be refused. There is some similarity in terms of the common law principles that apply. So if you're outside of Brussels and the Lugano Convention, for anyone familiar with enforcement of foreign judgments under English law, there is essentially no material difference between the rules governing recognition and enforcement of foreign judgments in Ireland and those under English law. So there's a number of criteria that need to be met to effectively enforce a foreign judgment. The first of those is that the court where the judgment was given had competent jurisdiction. The second is that the judgment is for a definite sum of money, and that's an important one. So it's effectively where you're dealing with judgments outside of Brussels or the Lugano Convention, it needs to be a monetary judgment. Thirdly, the judgment needs to be final and conclusive. And it obviously can't be contrary to public policy or natural justice in Ireland. And then importantly, a more recent principle that the courts have developed is there needs to be a material benefit to enforcing the judgment in Ireland. Importantly as well, there is no reciprocity requirement if you're looking to enforce a foreign judgment in Ireland under common law principles. I think if you go back and look at the very old common law judgments, the rationale there was that it was kind of based on international comity of courts, and reciprocity was an important factor there, but that was ultimately rejected by the English and the Irish courts in favour, I think, of a rationale based more on what's called the doctrine of obligation rather than reciprocity. So that is an important point. Just looking at some of those criteria maybe in a little bit more detail, in terms of the judgment being from a court of competent jurisdiction, that will be assessed by reference to Irish conflict of laws rules. So it doesn't necessarily, the court won't necessarily take it as a given if the foreign court itself felt it had jurisdiction. That won't be enough. The Irish court will look at it from an Irish conflict of laws perspective and consider whether or not the foreign court had jurisdiction. Now, generally speaking, if the debtor was in the relevant jurisdiction when the proceedings were instituted, or they submitted to the jurisdiction of the court, the foreign court, generally speaking, the Irish court will consider that the court was competent. I mentioned as well the definite sum of money criteria that effectively speaks for itself, but obviously if you have an injunctive or other type of non-monetary judgment, enforcing it at common law won't be possible. That obviously the position may be different under the Brussels regulation or the Lugano Convention, where it's not necessarily limited to monetary judgments. In terms of the judgment being final and conclusive, again, that effectively means that the judgment needs to be unalterable in the court that rendered the judgment. A judgment can be subject to appeal. You can still seek enforcement, but very often the Irish court will stay any enforcement measures pending the outcome of any appeal. So very often it is better to await the outcome of an appeal before seeking enforcement. But it is possible to move before then. But as I say, the court might freeze that pending the appeal. In terms of then the criteria about public policy and natural justice, they're probably a little bit more vague in nature and tend to be quite case specific. Obviously, it's Irish public policy that the court is going to consider when it's looking at enforcement under common law. If you look at the cases where they have refused enforcement under that criteria, it tends to be, again, very case specific. There's cases about polygamous marriage, gambling debts, and then judgments for multiple damages. I think effectively where there's a multiplier of a compensation sum, which wouldn't be the way the Irish courts would calculate compensation. So effectively, if you're looking at a judgment that is something that you wouldn't get under Irish law, then you may be in trouble under the public policy limb. The natural justice criterion then, again, the courts here we'll look for something quite substantial in terms of a failure in fair procedures. If there's kind of a technical irregularity or some form of a irregularity on the paperwork that doesn't necessarily go to the heart of the justice of the hearing that the person got in a foreign court, and then the Irish court may not refuse it on that basis. But if there is some substantial failing in the process in the foreign jurisdiction, then the court will obviously look into that, and they will look at it through the eyes of an Irish judge and consider whether if the same thing effectively had happened in Ireland, would it be considered a breach of natural justice. And then the final criteria that I'd mentioned was that there has to be a material benefit from enforcing the judgment in Ireland, and that's a principle that the courts have really only developed in more recent years. It can be, once there's effectively an indirect or prospective benefit, that is probably sufficient. But generally speaking, what you're looking at there is being able to say that the judgment debtor has assets within the jurisdiction, or that there's effectively going to be some purpose to enforcing here. If it's simply perhaps vindictive, or there's no real benefit to enforcing in Ireland, then the court may refuse it. So it is probably important in that respect that if you are looking to enforce here, that you do a bit of due diligence, see what assets there might be to enforce against, and whether ultimately there will be any benefit to it. That's both from satisfying the test, but also obviously from a practical perspective, that, for instance, if you were dealing with a non-European judgment, the costs won't be insignificant of looking for enforcement. So obviously nobody wants to be putting their client through a long enforcement process, and it turns out that there's nothing to actually enforce against. So it's both a substantive and probably a practical point. And then just maybe briefly some kind of procedural points about enforcement in Ireland that might be of relevance and interest. Generally speaking, obviously, again, a lot of colleagues on the call will be familiar when you're enforcing under the Brussels regulation or the Lugano Convention. You effectively, once you have an authentic copy of the judgment, a translation, and then the certificate that's required under the Brussels regulation and the Lugano Convention, once those are filed in court, you then effectively end up with a judgment that's as good as an Irish judgment. It can be enforced upon. Obviously, in the case of a common law, enforcement under common law, you actually have to bring a fresh action on the foreign judgment in Ireland. And that is done by way of what's called a summary summons in Ireland, which is a summary procedure that is effectively dealt with on affidavit evidence as opposed to oral evidence. So it should be a quicker process than if there was a full oral trial. Now, the court can, generally speaking, adjourn the matter to plenary hearing if, for instance, an issue arises in terms of refusal, or if a defence is mounted and the court needs to have oral evidence on the issues, it can do that. In terms of other practical things such as limitation periods, that generally speaking, because the enforcement of a foreign judgment is treated as though it's the enforcement of a debt as such, you're looking at a 6-year limitation period. So generally speaking, people will obviously move probably quicker than that on a foreign judgment, but you would be looking at an ultimate 6-year limitation period. And then, as I say, generally speaking, it will proceed on affidavit evidence, but there is the possibility of cross-examination as well in the process. And in terms of then the practicality of enforcing here, obviously, if you're looking to enforce under Brussels and Lugano, it's a lot more straightforward process, but obviously you can't always control the jurisdiction from which your judgment comes. So if you are in a common law, if you are going under the common law rules where you're dealing with a non-European judgment, I do think it is important, probably before launching into any enforcement of it, that you do, as I say, that kind of due diligence to see whether or not there is something to enforce against here, because the process going under the common law, while it might sound straightforward there, the courts are a lot less restricted in terms of what they can look into. I should have probably mentioned, actually, generally speaking, the courts won't re-examine the merits of the case. Obviously, they can't if you're proceeding under the Brussels regulation or the Lugano Convention. But likewise, under common law principles, the courts generally won't look into the merits again, unless obviously there is a point, they're less constricted in terms of the common law principles, so they can, but generally don't, unless there is a good reason or a good defence mounted by the judgment debtor as to why they should look back into the merits. So there is probably, under the common law rules, a lot more scope to cause a bit of mischief if you were a judgment debtor. and to drag out the proceedings than there are if you were proceeding under the Brussels regulation or the Lugano Convention. So I think you probably have to proceed with a little more caution if you are enforcing under the common law rules. And as I say, it's important to probably look at whether there are sufficient assets and whether your client is ultimately going to get something at the end of the day, having gone through the process and incurring the costs. So that's a general overview of the enforcement process here in terms of foreign judgments. So I'm not sure if anybody's any questions on any aspects of that or any of what Rory had to speak about earlier. We're happy to take any questions.
Hi, it's Wendy here. I have a question for you. I was interested to hear you mention the requirement for a material benefit before enforcement of judgments can be allowed. I did use those cases that you referred to recently in arguing a matter in the Singapore courts as well. And the reason why I had to use those cases was because the judgment that I was seeking to enforce in Singapore was from Korea, and it was issued in 2001. But it was only recently that the clients located assets in Singapore. So they've been chasing the judgment creditor around the world. And eventually it was only sometime in 2019 that they found assets in Singapore. The judgment debtor raised, the argument that you're way past the limitation period, 6 years since the judgment has been issued, you're out of time, the judgment can't be enforced in Singapore anymore. So one of the arguments we made was, look, there is a requirement of material benefit. So time cannot start running until it was reasonable for the judgment creditor to have ascertained that there were assets in Singapore. I'm not sure how this will be decided in Ireland if it ever comes up. The Singapore court did not have to decide on the issue at the end of the day because we were able to get out of limitation by relying on final and conclusive. Basically, the argument was that the judgment was not final and conclusive in Korea until the entire appeal process had been completed. And so the clients were quite lucky that the appeal process was completed in 2013, and we were within the 6-year period rather than starting from 2001, which was the first instance judgment. It's on appeal, so I don't know if this is ever going to come up again before the Singapore courts. But our alternative argument was that, look, time can only start to run when there are assets in Singapore. You can't expect a judgment creditor to just start enforcing a judgment in every single jurisdiction because of limitation period. And we did rely on those cases that you talked about from Ireland and to say, well, you should adopt the same approach in Singapore. I don't know how Singapore Court of Appeal is going to decide this because the matter's on appeal, but I was just curious to hear, in Ireland, when would you start considering the 6-year period to start to run?
Well, generally it would run from when the foreign judgment was delivered. And I think probably looking at the wording of our statute of limitation, you probably might have limitation issues, even if ultimately assets emerge later. Now, I think there's probably limited scope actually under the statute of limitations for the court to extend it in those kind of circumstances, even though it does obviously seem quite fair if assets, or perhaps there could be a fraud exception as well, depending on, I guess, how the assets emerged. So if it had been the case, and there would be an exception under the limitation period there, if somebody was obviously, if you could point to them hiding assets and point to it effectively as being a fraud. But I guess if it was just assets that a judgment debtor happened to acquire post the 6-year limitation period and honestly acquired them post that, I think it might be difficult to move on it. But I'm not aware of the Irish court of the Irish courts having to consider that issue. So it might still be one that they could decide differently, but I think absent fraud, it might be quite difficult.
Thank you.
So any further questions? For me, it was definitely interesting to hear that you need a monetary decision if it's not under the Lugano Convention or the EU regulation. So that's certainly something which can limit the possibility to enforce.
It's a very important point, and it's well established. I think, again, if you go back to the old case law, it goes to the idea of enforcing a judgment in personam versus a judgment in rem, and that injunctive orders are really a matter for the specific court itself rather than for a foreign court. So it's a very well established principle under the common law principle. So we won't be able to change that, unfortunately. So it is an important point.
Okay. So any further questions? So probably, yeah.
I have, yeah, thank you, Philippe, and thank you, Donghal and Rory for the presentations. I have two brief questions. Perhaps the first one for Rory. I don't know if perhaps you mentioned it, but maybe I missed it. Is there any experience in Ireland with the enforcement of exit awards so far that they have been recognized without going through the exequatur proceedings as the exit convention states, giving them the same status as an Irish domestic judgment? And if you know of them, because right now there are a number of exit judgments that against Spain that we're looking to enforce, and would be interested in seeing available jurisdictions. And the second one for Donghal, how strict is this requirement of material benefit applied at the beginning of this summary summons you were explaining? Do we need to state that we have reason to believe there are potential attachable assets that we are, through the process we may obtain discovery information as to the precise location of assets, or is it applied in a more strict way?
Roy, I don't know, do you want to take the first question first?
Sure, yeah, thank you, Borja. Look, a very interesting question. And in very short summary, Ireland has not really come to the attention of exit in any respect. I'm not aware of any decision being made against Ireland by exit or enforced against them under the Washington Convention. And that very much, I think, relates to the investment profile in Ireland. There are very few, if any, bilateral investment treaties between Ireland and investing entities. We very much follow the EU pattern and follow EU trade agreements, and we don't have, for example, very significant domestic resources that are the subject of, say, extraction by international investors. So, in short, we don't see it, and we certainly don't have the profile of a country, say, like Argentina, or obviously more normal activity in the EU. So no, we haven't seen any of it, and I'm very much looking for the opportunity to take a case against Ireland under exit. I don't think there's very strong consciousness of the extent to which emanations of the state are captured by the Washington Convention and the potential to come forward in exit. I think I see that as perhaps having the most likely occurrence is in the energy markets, where Ireland in gas and electricity is very exposed to European interests, and I think there's great potential there for a case to be brought. But at the moment, no.
And then just to take the second question about material benefit, you don't necessarily need to be at the initial stages of the proceedings. You would need to give the court some suggestion that either there are assets or may potentially be assets in the jurisdiction. You wouldn't necessarily have to come forward to the court with kind of, here is a list of assets we're going to enforce against. I think it would only be in a case where it was very clear that there was a complete shell company, for instance, where there was going to be nothing at all ever within the jurisdiction. I have seen applications where, for instance, you go in and it is a very vague suggestion there are assets, and you indicate to the court that you're still looking into it and that you have asset tracers and all sorts of people working on it, and you can update the court later in the process as to what you come across as well. So it wouldn't be an absolute mark against bringing the proceedings at the outset if you didn't have a complete list of assets or anything to enforce against. So it's probably maybe not as strict a criteria as perhaps I gave I might have given the suggestion it was a very strict criteria. It is probably strict in the reverse, insofar as if it's very clear there's nothing in the jurisdiction or never going to be anything in the jurisdiction, then perhaps you'll be in difficulties.
So thank you very much to Rory and Donald. So if there are any further questions, for the sake of time, I suggest that you direct them directly at Rory and Donald, and many thanks again. So I would like to move to Ryan, and I guess that Billy will also participate in the presentation of the dispute resolution practice of Miller Martin in Atlanta, and you have also additional office in that part of the US.
Thank you, Philip. Yeah, so my name's Ryan Kurtz. I'll speak on behalf of the firm and also introduce my colleague and partner, Billy Eiselstein, who is also a partner here in our dispute resolution group in Atlanta. We're obviously pressed for time and want to keep this short. So I want to just give you a brief idea of kind of what we do. We do have 4 offices here in the US. Billy and I are both here in Atlanta. Our ADR practice groups are really, there are a number of them, including we have an appellate practice group, bankruptcy and creditors' rights, a class and collective action group, crisis management, obviously a business litigation group. We also have employment litigation under our dispute resolution group, although historically, for various reasons, until a few years ago, we sort of had employment and labor as sort of a different department within our firm. ERISA and employee benefits is one of our practice groups as well. Healthcare litigation is a growing area. We have a very strong healthcare litigation practice. Insurance litigation, intellectual property litigation, product liability, also professional services, which includes legal malpractice cases and other sorts of accounting malpractice and professional malpractice cases. Trade secrets and non-competition practice group. We also have wage and hour practice group, which is sort of related to our employment and labor group, and white collar and corporate, as well as a construction ADR practice group. We've also done a lot of work, particularly in recent years, designing ADR programs for our clients. This typically comes up for our corporate clients and their relationships with their employees. And there's been sort of a movement in the United States to, for various reasons, including risk minimization, to seek to compel arbitration of claims by employees against employers. And so we've been very active in that area in recent years. That practice, frankly, can be a little challenging, particularly with clients that have offices throughout the United States, because we do have, as many of you know, both a federal system and a state system, and many of the laws related to the employer-employee relationship and arbitrability do touch on state laws. But we've been very successful implementing those programs for clients with multiple offices throughout the US. I'm going to just say a couple of words about arbitration, and then Billy is going to talk about mediation and some of our representative cases. We do a lot of arbitration work as well. I think arbitration is still a growing practice, frankly, in the US. It's certainly quite common. And I think, there are still, I think, even within our firm, sort of mixed opinions about preferring arbitration versus litigation, whether there are cost savings. There are lots of pros and cons between the two dispute resolution mechanisms that I won't get into. But the two most common administering bodies that are used in the United States are the what's called the AAA, which is the American Arbitration Association, and the other one is JAMS. And so most U.S. domestic arbitrations tend to fall under one of those sets of rules and are administered by one of those administering bodies. We also do a fair amount of work outside of the U.S. and international arbitration matters that are governed by a variety of different rules and administering bodies. We also have within our ADR practice group a number of certified arbitrators as well as mediators. I don't frankly know how this works in other jurisdictions, but here in the United States, it's not uncommon to have practitioners who maintain their practice, but they also serve as mediators in disputes in which obviously they don't have a conflict of interest, or they serve as arbitrators. So we do have a number of practitioners that arbitrate matters for JAMS and or the AAA, or they serve as mediators. With that, I will turn this over to Billy, who will talk to you about mediation and some other particular cases that we've been engaged on.
Good morning and good afternoon. When we think of alternative dispute resolution, most of the time, I guess we at least here think of that as being arbitration or going to some kind of private tribunal. But when we are litigating in the court system, there is still, very often a either voluntary or court imposed obligation to mediate and to go to a private party. Sometimes it can be court annexed, where another judge serving with the presiding judge over the case will serve as the mediator. But so the big difference, of course, between a mediation and an arbitration is that the mediation is not binding. At the end of the day, there has to be a voluntary settlement. And mediators come in kind of all kinds of flavors around, and you end up in a particular jurisdiction kind of knowing which are the ones that are maybe have a stronger personality to convince clients to settle. And it is effective often when you have a client hearing directly from somebody that's uninvolved what the strengths, or more likely when they're pushing settlement, the weaknesses of the case are. I'm sure you've experienced it too as an advocate, as an attorney. You tell the clients the weaknesses of their case, and they say, you're not on my side. I've hired you to be on my side. But the mediation happens, at least in commercial disputes or business related disputes, virtually in every dispute, I would say, that goes on for any length of time. Of course, sometimes contracts have a requirement to mediate, but separate from that, many court rules will have a requirement to go mediate. And even if they don't, the judges often will order the parties to go mediate. And then we've had situations where if you feel like you have an opponent that is not being reasonable, or an opponent that's hard to discuss resolution with, you can even go to a judge and ask the judge to order mediation. And again, because they view that as a way to clear off their workload and dockets, that would almost always be granted. So even almost maybe to a fault, many if disputes get settled through mediation, and you wonder if that means that attorneys don't know how to settle cases on their own anymore, because we rely so much on mediation. But it's something that's become popular and is baked into the court system now. Ryan, and mediators are often certified. Probably most, if not all, states or bar associations will have a process to certify mediators, and then they have a set of rules and kind of ethics obligations that they sign on to. That's not required. I mean, you could hire anybody willing to serve as a mediator, but most of them go through some type of association or certification, so that there's some basic training and ethics that they comply with. Ryan also asked me to talk quickly about just some representative engagements that may give an example of the types of litigation that we do or that that come to us. And as I was thinking about it and things that may be of interest to this group, one of the types of cases that we see a lot and that becomes kind of a lengthy, expensive dispute is when competitors are suing each other, whether it's under a non-compete or a trade secret or intellectual property fight. Those can get very expensive. You have competitors who view the litigation process as giving them a competitive edge, or just kind of put them in a position of having no choice but to defend against an aggressive competitor who seems to be using the court system as a way to either intimidate or cause a competitor to spend money. But in one case that was several years ago that actually came to us from Taylor Vessing and through the World Law Group, you had a German company and a company in Georgia who are competitors in a relatively specialized industry, so a limited group of customers. And that case went on probably for 5 or 6 years in both federal courts, state courts. We had in at least 2, if not 3 states, we had proceedings going on. It was really a kind of a sprawling dispute that when it was on appeal to the United States Court of Appeals, finally settled. And that settlement probably was not accomplished, but it was what began the settlement process was a court-ordered mediation at the appellate level. The Court of Appeals, before it would hear argument, required the parties to sit down and mediate with an office that is established by the Court of Appeals to do that very thing. And then just a similar case in my mind in terms of the relationship of the opposing parties, being one where they really disliked each other and were willing to litigate intensively. We had a case that was brought in Arizona. It went on for 8 years and was appealed a couple of times. There was parallel litigation in Georgia. And I thought I would mention that not just as this example of competitors deciding to fight for whatever it took, but also to point out the difference in the court systems. So we have a federal court system, and then each state has its own state court systems, and those are separate systems. They in some ways can run in parallel paths. In some ways, the federal courts are limited in the types of cases they can take. But we were in federal court. You've got a fairly uniform set of procedures and method of litigating across the country in the federal court system. So we were litigating, even though we're here in Georgia, in Arizona federal courts for several years, and you do in most cases need to hire somebody in the local jurisdiction as your local counsel, which we do for people litigating in Georgia or Tennessee. And then that's something that happens, but really the bulk of the litigating is done by us, even if it's in another state, and that's particularly true in the federal system, although you have similar processes in each state. So those are some representative things that we've done. Ryan may have a few things that you wanted to add to that.
Yeah, so the last thing I'll mention is what we refer to as a 1782 proceeding. These are could be of interest to this group. 1782 is a provision of our U.S. Code. It allows for foreign litigants to seek discovery located in the United States in aid of a foreign proceeding. So if you have a litigation matter abroad that touches on the U.S., that one of the parties or even a non-party, may have evidence located in the U.S., whether it be documentary evidence or even testimonial evidence. We've assisted a growing number of clients with these proceedings in the U.S. I will say that the U.S. Supreme Court very recently clarified that this provision is not available into foreign arbitral proceedings. So previously there was a split of authority in the U.S. A number of participants in foreign arbitral proceedings were coming here to the U.S. trying to obtain kind of U.S. style discovery, often in cases in which they couldn't get the discovery under the rules available to them through the arbitration proceeding. But many of the U.S. courts were allowing that. The U.S. Supreme Court last year in June ruled that the statute does not apply to foreign arbitral proceedings or any arbitral proceedings for that matter. It only applies to essentially court proceedings and perhaps administrative proceedings as well. But it is an interesting tool that is available, and we've been seeing an increasing number of applicants in this area. With that, I think we're almost out of time. I'll turn this back over to Philip, and we certainly appreciate the opportunity to speak to everybody this morning.
Yeah, thank you very much. That was very interesting. It's also to see how it works differently in different countries. Like, for example, in Switzerland, courts, they usually get involved in trying to settle cases. So they would not send the parties to mediation. They would try to propose a settlement by themselves, while I believe in many countries that would be considered to be inappropriate for the courts to be involved in this way. But here it's kind of a standard, and of course, even if you have a court which is composed of 3 or 5 judges, and there is one responsible judge who would tell you what his provisional view of the case is. It's quite something which inclines then the parties to settle their dispute, because it's, unless you feel that you had not yet the chance to tell everything, it's quite unlikely that the case will end up completely different what you have been told by the responsible judge. So and then you do it by mediation, which is certainly also a very good tool to address those cases where the parties need kind of a third party to help them to find a solution. And so thank you much for that. And I'm sorry that it's already 4 o'clock. I had hoped that we would have some time today to also kind of introduce the new people. I promise at least I will make this proposal to my 2 co-heads, that next time we will start with the introduction of the people at the beginning, so not to miss it again. Because I also find it very interesting to know better the colleagues at the various work group firms, which is one of the core things, that if you have an issue somewhere, you know somebody, and you can introduce them to your clients. Of course, we have some contact partners, but to know also the people from the dispute resolution team, that's great. Just maybe two more minutes. Question from our end is whether, apart from this series about enforcement of decisions, if you have any particular idea of a topic to address in one of the upcoming dispute resolution meetings here. I thought that maybe like ESG disputes could be a topic. It's not so hot yet in Switzerland because we're always a bit late, but I know that in many other countries, this has really become a very important topic. And for example, it could be something to be addressed by like 3 or 4 countries, how you deal with ESG disputes. any other proposals, I would be really interested.
Philip, I think ESG is a very interesting topic, and we're seeing from climate litigation to like there's a series of I wouldn't say copycat, but there's a real trend, and we're seeing an increasing number of lawsuits, and clearly plaintiffs are looking for what's going on in other jurisdictions and are trying to mimic it or replicate it. And I think it may be something that would be of interest for all of us.
Okay. And would you from Canada have would you be a potential participant? Do you have anything to contribute here?
Yeah, we can certainly put something together. We've looked recently at like everything that like we've done I wouldn't say a full worldwide search, but like we've looked at what has been done in many jurisdictions, and we certainly have materials that we could put together as a starting point. And if anyone else is interested to participate into that, we could do that together.
Yeah. Anybody else here who would be interested to participate in such kind of a like a round table, or however we organize it? I think the Netherlands.
I would be interested.
Okay, good. Because in Europe, it's kind of Netherlands, they are at the forefront here. So I think that would be definitely good if Bart Adrian participates here. Anybody else?
Hi, from Thailand.
Hello.
Hi, it's Wari from Thailand. I'm new here, and I thank you all. I like to learn from you guys. So I try every opportunity. If I can join, I would do.
Okay. Okay.
Thank you.
Okay.
Philippe, sorry, from Tom in London, I'm sure we could volunteer something on ESG litigation as well. I would be volunteering a colleague rather than myself, but that's the easiest type of volunteering. So count us in, and I'll happily find someone better placed than I to discuss it, because it's not.
Okay, that's excellent. I think like four is a good number. So thank you very much, and I put down the names, and then I think I will be. And then my two co-chairs, Wendy and Ryan, will be in contact with you, and to see whether we can do that at the next stage, or otherwise it will be the second next. So, and thank you very much for staying another 6 minutes. And now I think we need to close that. And as promised, next time we start with an introduction of everybody, so that we know each other a bit better. And thanks again to Ryan and Billy about presenting Miller Martin, and to Rory and Donald about the presentation, the very interesting presentation about the enforcement of arbitral awards and court decisions in Ireland. Thanks a lot, and have a good day. Bye.
Thank you all.
Bye.
Thank you very much.
Everyone.
Thank you.
Bye-bye.
Bye. If we call it America, Evie goes first alphabetically. If we call it the United States, Jorn should go first. Do you have a preference, folks?
I would say you already been talking about liberalization in the US, so maybe you start, and then I'm with you with the German experience.
Okay, and then I look forward, Victor, I'd love to hear what's going on north of the border. Let's begin by welcoming everybody. Many of you don't have your cameras on, and I assume that's because you were out partying late last night, because you're multitasking. If you'd like to turn your camera on so that we can see you, that's great, but we certainly understand if you have other things going on in the background, or you're working from home and you don't want us to see, your cats. Yeah, Evie Norwinski from Arnold and Porter has graciously offered to give us an update on America, where we have many, many things going on in the United States, with questionable likelihood of success on many of them.
Sure. And
I'm going to mute myself for that reason. Evie?
And Hannah, I have some slides, but I'm not committed to using them. So is it too late to put them up? They're nothing but kind of a placeholder.
You're absolutely welcome to if you click that green share screen button below. So I would open the slides up in presentation mode first,
okay,
and then hit share screen.
Okay, slideshow from beginning. Okay, now I can't do this really quickly.
No worries.
Oh, that works, right?
Perfect.
Okay.
Great.
So, good morning. I'm getting a little feedback. Good morning, good afternoon, good evening, everyone. I, along with my U.S. colleague, Lewis, are going to talk a little bit about the U.S. cannabis laws. I'm going to briefly provide an update on what's been happening, and then Lewis and I can start a dialogue about what this means for our clients, either in the cannabis space or who want to get in the cannabis space, and what we think this means for the future. So just, here we go. No. So just a little bit of context before I begin, and I think everyone knows this, but in the US, we have conflicting laws between the federal laws and state laws. So for the last 10 years, roughly, the states have been marching forward in legalizing cannabis within the state, but it still remains fully illegal under federal law. So for example, if you're a cannabis company in California, you might be licensed by the state of California and you are operating your cannabis business in full compliance with all of California's regulations, but you're still in violation of federal law. And this means you can be convicted under federal law criminally. It means that you probably don't have access to the banking system in the US, which is mostly governed by federal government. And you can't deduct operating expenses on your federal tax return, which is a significant disadvantage. There are a number of other consequences from this, but bottom line is we have two different laws and they say different things. And it's creating a lot of problems for our US businesses. So where are we federally in all this? Well, we're starting to make some limited steps forward under federal law, but they are very limited. There's been a fair amount of activity the last 6 months of this year, and I have 3 of these things up on the slide. The first I want to talk about is in October of 2022, just a couple months ago, President Biden issued an executive order pardoning all offenses for simple possession of marijuana. And while this sounds significant, it is, but it's not significant because of the pardons. There are, excuse me, in the US, there are very few convictions for just simple possession. If the feds are going to go after someone for marijuana offenses, they usually charge them not only with possession, but with distribution or conspiracy to distribute. There's often weapons, money laundering charge involved. So this really isn't statistically that significant in the US. What I think is more significant is the fact that the Biden administration even issued this. Biden had not shown a willingness to get involved in cannabis reform up until this point. So this is what some might call a significant departure for the administration to actually weigh in on this. And it allowed Biden to do it with concepts of social justice in mind. Most of the people who have cannabis convictions in the US are minorities, and there's a real social justice focus in both in Congress and the administration in rectifying the prior laws. What I also think is significant about Biden's executive order is it mandates that that HHS, the Department of Health and Human Services, as well as the Attorney General, start the process to review marijuana scheduling. In the US, as with the World Health Organization schedules, marijuana is in the most restrictive category. In the US, that's Schedule 1. And that means that the US has deemed marijuana has no medical uses and it has a high potential for abuse. And therefore, it's going to be put into the most strictly regulated categories of drugs. So Biden asked HHS and the AG to begin this review process to see if marijuana should be rescheduled. It doesn't mean anything will happen in rescheduling, and certainly doesn't mean anything will happen soon, but it is a step in the direction of either rescheduling or potentially descheduling, taking cannabis out of the regulated drugs. The second development, and this was significant, in November, Congress passed the Federal Medical Marijuana and Cannabidiol Research Expansion Act. And President Biden signed it into law just about a week ago. This is significant because it's the first standalone bill that the US Congress has passed related to cannabis. And while it doesn't make any wholesale changes in and of itself, again, it signals Congress's willingness to start addressing cannabis issues. We call it the Research Act. What the Research Act does is it relaxes some of the rules governing licensed research, medical research on marijuana. It doesn't wholesale change them, but it does provide for fewer requirements in the areas of applications, application approvals, and security surrounding the storage of cannabis for research purposes. So it does make it a little easier. What I think are some of the most significant provisions in here are the provisions that deal with licensing. They not only mandate that the DEA, which issues licenses for research, that's our drug enforcement agency, they not only mandate that DEA issue licenses if someone has met all of the requirements, but they also provide a time limit. DEA basically has to act on license applications within 60 days. There are some extensions that are given if more information is needed, but it sets a time limit. This addresses a problem we've had in the US, which relates both to research and to production of cannabis for research. The existing law allows for those activities, but DEA tends to sit on a number of the applications. So you apply, for example, to be a researcher or to manufacture marijuana for research, and your application can sit for a year or more. And DEA takes a very conservative approach with respect to marijuana. So it might ultimately end up denying your application. This tries to cabin DEA so that it has to issue an approval if you've met the requirements, and also it has to do so within basically 60 days. So along those lines, it also asks the Attorney General to ensure that there is both a diverse and an adequate supply of cannabis for research. This has been another longstanding problem where we have one supplier of cannabis for research And that supplier is providing cannabis that was available when Lewis and I were in college. So it's old stuff. Well, it's not, the cannabis itself isn't old, but the form of cannabis is old. There is so many new things on the market that our researchers just aren't able to get a hold of. And so this tasked the Attorney General with making sure that the supplies are sufficient for the needs of researchers. The one other piece that I thought was significant is there's a smaller provision in there that provides a safe harbor for universities and some other institutions to possess and manufacture and distribute cannabis for medical research purposes. In the US, universities receive a lot of federal funding, and they've been reluctant up until this time to conduct research with cannabis because of all the restrictions. They don't want to run afoul of federal law and risk losing their federal funding. So this provides them a little more in terms of assurances that they can go forward with this research, and they are within a safe harbor for doing so. The last thing I want to report on is the Safe Banking Act, which essentially it dispenses with the money laundering, federal money laundering prohibitions on cannabis money. It would allow banks to offer services to cannabis businesses and anyone else who would be accepting cannabis money. The Safe Banking Act has been up for vote, I think 7 times now before our US Congress, and every time it has failed to pass. This year, there's been a real effort to attach it to federal funding bills, and it was recently attached to the defense funding bill that needs to be passed every year by the end of the year. But ultimately, it was removed from that bill, so we no longer, I think our optimism for passage of the Safe Banking Act has diminished a little bit. There is talk of attaching it to other funding bills to try to get it through, and we'll see where that goes. But there have been some additional attempts. At the state law level, in November, 2 states legalized marijuana recreationally. Those were Maryland and Missouri. This map I'm showing you is not quite up to date, but it gives you a sense of how many states have legalized cannabis in the US. So we're now at more than 3/4 of the US states have legalized cannabis for either medical or recreational purposes. And more than half the US population lives in a state that has legalized cannabis in some form. So that's a lot of pressure being exerted on the US Congress to make to pass some sort of legislation to try to resolve this difference between the federal and the state law. So what do these new laws mean for cannabis businesses and for the future of US law governing cannabis? And Lewis, I'm going to invite you to weigh in here, and maybe we can start with a discussion of what this means for potentially rescheduling or even descheduling cannabis. How might that work? When might it get through the administrative process? So I'll let you weigh in with your thoughts on what all this means.
So for those of us that joined early, Evie and I were commenting that we have both consistently misjudged the timing of federal reschedulization for about, I've been wrong consistently for at least a decade. Schedule I drugs it's just inconsistent with everything else we're doing. Because a drug on Schedule I is a narcotic that has no possible medical use and therefore cannot be researched, cannot be studied. somewhat inconsistent with what Evie just told us about the new Research Act. A Schedule I drug is Schedule 1 and Schedule 2. It is, I think, 5 different levels of government scheduling, and each tier has a different level of government regulatory burden. If you're in 1 and 2, you have a serious tax problem, because if you're working with drugs in Schedule 1 and 2, you don't get a tax deduction for your expenses associated with operation. Okay, it's an oversimplification. But as a tax lawyer, I got into cannabis originally because of trying to reduce the impact of that. As soon as they reschedule this beyond Schedule 2, I'm out of the game. Okay, so the government's inability to act in the United States, in this case, is good for only probably a handful of tax lawyers and not really good for anyone else. It's silly. So because it's so silly, I thought for years the government would reschedule it to at least 2 or maybe 3. The fight there seems to be, and Evie, you're going to be more knowledgeable here than I am. Tobacco companies want it on 1 tier. Pharmaceutical companies would love to have it on tier 2. And the social justice people would like to have it completely unscheduled so that it can be sold anywhere pretty easily. If it's on tier 2, the distribution will largely be governed by pharmaceutical companies, as I understand it. Evie, is that your understanding? Is that sort of correct?
Yes, it is. It needs certain approval, and it is highly regulated. It's not fully illegal, but highly regulated. So think of opioids. We've all seen in the news the last number of years. Opioids are Schedule 2 drugs.
I think fentanyl is even a Schedule 2.
I think it is. I think you're right.
And fentanyl, for those of you whose countries are not plagued by it, is a serious problem in our country, because it's highly addictive, worse than opioids, and causes many deaths. So that's the fight. And I guess I'm curious if anybody's heard any prediction as to when the DEA might make its rescheduling determination in light of the executive order.
I don't have a prediction, but just to give a sense of what it would take to reschedule, there's a whole process in the United States. It starts with the FDA, the Food and Drug Administration, and they conduct research, they consult with the National Institute of Drug Abuse, and they come up with a recommendation. And then that recommendation has to go through many, many levels of approval under FDA. They then pass their recommendation on to the Drug Enforcement Administration, and the DEA cannot question the scientific and medical determinations made by FDA, but they can bring their own input to bear on whether it should be rescheduled, if so, at what level, or whether it should be descheduled. So there are a lot of processes that this has to go through before DEA even makes a determination as to what can happen. Once it does so, it then needs to put it out for public comment. So that's a whole, 6-month process. Then it has to take the comments into account before it finally reschedules or deschedules. Most of the rescheduling decisions are in the 2+ years. The last time there was a petition to reschedule marijuana in the US was I think the request was made in 2009, 2010. It was a 5 to 7 year process before DEA then determined that marijuana should stay in Schedule 1. So we're not looking at any fast change if we're going through the rescheduling route. I'd also like to hear from others about what you've done in terms of the international treaties. the US is a signatory to the conventions on narcotics, which of course bind us to keeping cannabis at a highly regulated, in a highly regulated category. And if we descheduled or legalized cannabis, I think that would violate our treaty obligation. But other countries have done so, and I'm not sure that is the main issue holding us back. But I'd be interested to hear what other countries have gone through in terms of international treaty obligations.
Maybe just briefly from the German perspective, that's one of the major issues in the liberalization efforts in Germany, because we're also part of the UN Convention. And there are scholars who say that we really have to just simply terminate the convention to be able to liberalize. Others see different routes, but it's a tricky issue, and it's one nobody really has a solution for so far. Just as a brief comment, I'm coming back to Germany later.
My understanding of the US position at this point is if there's political traction behind descheduling or legalizing marijuana, that we will do so and we will violate our treaty obligations. We do that from time to time, and this is an area where that would not hold us back by itself, but it certainly is going to be discussed and will be of some concern and might factor into how quickly we move forward.
Hi, everybody. It's Victor from Goodman's on Canada. Obviously, we've had a regulated regime for some time. This was an issue that was identified when our laws were evolving back in 2017, 2018 to what it is today. Interestingly, while various academics and international persons identified this as an issue, I think there were 3 particular treaties that we're parties to that would be affected. I haven't actually heard anything come out of it. I mean, obviously our laws have changed and our industry exists. And I'm not an international law expert. I don't know what happens when you violate an international treaty and who sort of brings an action against you. Is it another country? And maybe because no other country has brought an action against us. I haven't really heard anything on that front in Canada. So not sure if anybody who is a better international law expert than me have a view of why that is, but it was identified at the beginning, but nothing's happened since, as far as I know.
Okay, and I know WHO is looking at this, and their opinions and findings and determinations would have a significant effect on how the treaties treat marijuana. So this could resolve itself as more research is done on cannabis, both in our own domestic countries as well as by WHO.
I wonder if there are other countries that face the schizophrenia that we have here in the United States, where 27 states basically allow free recreational use, with the only the primary limitations are things like not selling near a school, near a high school. And yet, on the federal level, this is a very serious crime, so much so that banks won't bank businesses in the area. Until last week, universities couldn't do research. Any other countries face that level of schism between local laws and national laws and international laws? Once again, we have the privilege of being unique.
Yeah, the only thing I would say from the Canadian perspective is because of the way our federalism work, some aspects of cannabis are regulated by provincial law. So like the actual, retail distribution and health aspects are subject to provincial law. So you'll see on the adult use recreational distribution side, the laws are slightly different across provinces, but the legalization is still under federal law. So not exactly the same as yours, but we do have that nuance.
And I think that, go ahead.
Sorry. Yes, similar in Germany. Narcotics law is federal, so the federal government decides on the legality and the legal framework, but enforcement activities are state are driven by the states, and depending on the political colors of the local governments, they either enforce it very drastically or sometimes don't even enforce it in by any means. So on the enforcement level, there's a big difference, but not on the legal level.
So
Yeah, just to give you a, sorry, go ahead, Evie.
I was going to wrap up the U.S. so that others could tell us about their laws. But just to wrap it up, all of our conflicting law issues are not likely to be resolved unless cannabis is legalized at the federal level. Louis, your prediction of when that'll happen?
Oh, it will definitely happen. But it's not gonna happen for quite some time, because and I think the group that wants broad-based legalization with few government oversight other than keeping it out of the hands of kids, that segment of the constituency is getting stronger as more and more states legalize. At some point, it becomes so absurd that you had to have a federal law different from the states, from the law of 50 states. As it stands now, if Evie put up her map, you could guess pretty easily where all the largest retail establishments are. Take a look at, if you put the cities in, if you can't buy in Wyoming because it's still illegal, trust me, there is no shortage of opportunities for folks that live in the northern part of the state to go to Montana, or the southern part of the state to go to Colorado. 5 years ago, there were issues about people buying in one state and going into another. I have not heard anything in 5 years. And Evie, maybe you've heard otherwise, but it's enforcement at all levels has become a joke. It's only used by the police if they need an excuse to arrest someone, but otherwise there's very little enforcement against marijuana in the United States for at personal use size. I'm not recommending that people drive across with truckloads. So I don't know, 10 years, Evie?
I was going to say 5. I'm a little more optimistic. It will not happen, certainly will not happen this year. We have a new Congress coming in January, and I have my doubts that the new Congress will make wholesale reform on cannabis, but we'll see. Safe banking.
Many of the grow states are quite going to be more powerful.
Mm-hmm.
Kentucky is rumored to have where it's illegal in Kentucky, and yet it's rumored to be one of the largest grow states in the country. So, Jorn?
Yeah, so maybe
talk to us about a country that's more normal.
That's what you may think, but maybe I think yes, you need to just simply before I can share my desk, you need to end sharing your desktop, Evie.
Okay, I thought I did.
Or give us a billing number for some of these matters.
Okay,
We should be there. Okay. So I share my screen if it works.
Sorry about that, Evie. I didn't mean to turn your video off. I was trying to stop your screen share.
Hannah, do you have to authorize Jorn to? Okay.
No. So Jorn, I would suggest unsharing your screen, bringing it into presentation mode, and then there we go. Okay, perfect. Sometimes people have a little issue with the screen share, but we can see it now.
Yeah, that's great. So yeah, we're talking about Germany, and that means we're talking about a country where we had a big change in 2017. I think I told about this, in previous sessions of this group. We have a legalized medical cannabis field since 2017, which means that medical cannabis can be sold in Germany to patients. It is only on prescription, of course, only through pharmacies, highly regulated. And there is even the possibility to have medical cannabis reimbursed by statutory health insurance funds, which is something that was a hard battle to achieve. Nevertheless, some of these health insurance funds are still very hesitant because they have a very conservative view about medicine. So there are some court battles going on about what the criteria are to get free marijuana for medical purposes. That's still not decided finally what these criteria are, but it's a very high threshold. On the demand side, the German cultivation cannot really fully serve the German market for medical cannabis. There has, of course, because it was illegal before 2017, there were no professional growers of cannabis in Germany. But the government at that time wanted to establish a homegrown German cannabis business. And what they did is they started a tender process to grant licenses for cultivation. And in the end, after failure the first time because of formal issues, in the end, 3 companies won the tender and are able to grow in Germany. But it took a lot of time, was very costly because all the security features for those cultivation operations are very, very high. So the first harvest took place in 2021. That was 4 years after liberalization, and it's still tiny fractions of the German medical cannabis market that are served by German producers. So what we do have is a large import market. There are imports into Germany, and the government has its wish is to decrease that level. But since the demand is quite high, it will certainly not be possible. Major import countries, Canada, the Netherlands, there we have the issue, and that is also something to do with the UN conventions, that under German law, it is only possible to import from countries which are formally sticking to the rules of the UN Convention on Narcotic Drugs, which leads to very few countries being able to serve the German market. So the Netherlands, of course, Portugal, but Victor, when Canada liberalized recreational some years ago, there was a big discussion among Canadian growers whether they would still be able to import into Germany, because if you read the letters of the law and of the UN Convention, Canada doesn't fulfill its obligations under the convention. A, they have liberalized recreational. B, there is no central cannabis agency, that there's a state agency that buys the cannabis and resells it to foreign countries. But nevertheless, the German government sort of chose to ignore this issue, because if they had stopped importation from Canada, that would have meant that the demand couldn't be served. But this is a very tricky issue, and it's still not really resolved, because in particular German growers, they're trying to get to court to force the government to enforce its own rules and the UN rules. So this is one of the things that may be something that, for example, the US thinks about, because if you have imports from the US or exports to other countries of marijuana grown there, and then other countries have the same rules and also don't import because recreational is liberalized on a federal level, that may play into this. I don't know, just a guess, because regarding Canada, this was a big issue. So that was medical cannabis. That is being seen as a success in the German market. It's accepted. There are professional structures now. There are large online pharmacies in the market, major players who are building brands, and they now want to be in the new world. And we have a new government now. It's exactly 1 year ago. The new chancellor was Olaf Scholz, came into power after 16 years of Angela Merkel. And his government is a so-called traffic light government, means it's a government of the Social Democrats, the Greens, and the Free Democrats, which are sort of like a liberal party here in Germany. So ideologically, these parties often clash, but they don't clash in one issue, and that is cannabis. That was one of the major points that was resolved very quickly while they were negotiating the new government. All these parties for a long time wanted to liberalize cannabis, also recreational cannabis. Therefore, this is one of their major projects for the 4 years they have. And this means that they have been speeding this up. What you see on the right is an excerpt from the coalition agreement, which gives you one of them all the main points. A controlled distribution should be established, similar to Canada, only for adults, licensed stores. Quality is important, and the major justification for doing this is that organized crime should be pushed back, that marijuana users shouldn't be exposed to other more dangerous drugs by the local dealer who have the same once they've drawn you into cannabis, these kinds of things. So that was early on in the coalition agreement already. So quite recently, everybody was waiting for what actually will happen. Long time, nothing happened, but that was probably also because of still the Corona issues. And then in February, of course, the Ukraine war starting and the German government having other priorities. But nevertheless, some weeks ago, the first so-called key point paper of the government came out. So it's not yet a draft legislation, but it's a paper listing the major points that the government sees and the major things they want to achieve. And the first thing they mention is, of course, all these legal issues, and we've touched upon them, talking about the US. Germany is part of those international treaties, and under those treaties, it's not easy to reschedule cannabis. It's easy to reschedule medical cannabis. That's okay because there are some exceptions in the convention, but it's not so easy for recreational cannabis. And the German government is discussing various options. They do not want to terminate or you just simply leave the UN conventions because they do not see it as a good signal. And Germany is usually very UN friendly, meaning they are trying to uphold international law. And if now Germany leaves a UN convention for its own purposes, that's not being seen as a good thing to do. So they're trying to avoid that. Therefore, they're wondering whether they may issue a statement that there is some justification under the UN convention, but it's still being discussed. And since Germany is part of the European Union, there's another issue, and that's even more tricky because the European Union has binding laws. Narcotics law is part of the national laws. So the EU doesn't have much to say when it comes to narcotics law. But on the other hand, there are various declarations and directives that have been issued over the last decades in which there's a clear tendency on the European level to not allow recreational cannabis being liberalized because the dangers of recreational cannabis are being underlined in all those treaties. Some people say the EU demands criminalization of recreational cannabis use. And therefore, there need to be consultations with the EU. Probably once there is a draft law, it also needs to be sent to the EU Commission and to the European Council for approval. And it will be interesting to see how they see it. But the government is quite optimistic that they can overcome those European obstacles. But many in the industry are fearing that this may, in the end, be the killer for this law. Yes.
Jorn, how do countries like Portugal and the Netherlands, members of the EU that have a far more liberal recreational cannabis market?
That's everybody's playing tricks here a bit. I would say Portugal actually does not really have a liberalized recreational cannabis market. They are growing a lot of cannabis and they're selling it to many places, but the recreational use is not really liberalized. Luxembourg tried, but they failed because they had a very ambitious law. Okay, it's a very small country. The Netherlands is an interesting example because in the Netherlands, on a formal level, using recreational cannabis is and has always been a criminal offense. There's a criminal sentence. There's a sentence in the statute for using recreational cannabis, and that's the Dutch approach, a very lenient approach. It is not enforced. So that it's in the law, it's a crime, but nobody enforces it, and so it's simply going on. This is something that the Dutch say is not part of the UN treaties. So they only demand that it's a crime. They don't tell you about enforcing it. But of course, this is not the route the German government wants to take, because it's a bit, yeah, dodgy, this doing it like this.
But that's what has caused so many of our problems in the US. There's no federal enforcement, so people go forward with these businesses, but because it is still illegal on the books, it creates so many different issues. Banking
Yes.
and taxes being at top of the list, but it just, you cannot, federal courts will not decide cases related to cannabis because it's still illegal federally, and they don't think courts should be used to work out, for example, contracts or lawsuits over investments. So it's the worst of all worlds to have the laws on the books, but not have it enforced because of the uncertainty, I think.
Yeah, that's also the position of the German government. What you also see in the Netherlands is a big problem because, because there is no enforcement of the law that's in place. It actually led to highly criminal activity because there are a lot of drug marijuana cartels in the Netherlands. There's a lot of crime around this, and so although it was sort of like de facto liberalized and not criminalized, there's still no legal distribution in itself, because the traders are sort of like illegal, but the end users are legal, and that's also not a model that anybody should follow. That's and also our Dutch colleagues would support that view. So that's the issue. Yeah.
I was just I've heard recently, it's something that it didn't occur to me before, which is two unintended consequences of local legalization in the United States. One is that states, because cannabis is legal, it's legal to possess and use cannabis if purchased at a licensed retail outlet. Police have stopped enforcing basically all cannabis laws at the possession level and the use level, regardless of where people acquired it. Okay, which has blossomed the illegal market because it's so much easier than it used to be. Not so much at the grow level, but at the we'll call it the informal retail level. Joe's backpack at the high school. On the other side, because of legalization, the cartels have been pushed out of the cannabis importation market. And those people who used to import and smuggle cannabis have now shifted to far more dangerous drugs. And I knew about the first, I hadn't heard about the second. So law of unintended consequences.
Yeah, you can't foresee everything. Okay. So what is the so the key points, besides all those problems with the international and European laws, is that, in a way, the Canadian model probably has been part of the thinking of the German government. There should be licensed stores. It's not really clear whether pharmacies should be part of this, or some pharmacies do want it. Some others say we are not drug dealers, so they don't want it. Among pharmacists, there's a big discussion at the moment whether they actually want this. Some desperately want it because it's a big market. There's a bit of a unclear position regarding online sales. There was a first draft of this paper, which highly pushed online sales and said, okay, this should be done on the online channels because it's safer and everybody reaches it, even in rural regions. But the second version that came out a week later, it didn't have this online pharmacy thing in, and that is something of big concern, because most of the big players in the German cannabis market at the moment, the medical market, are actually positioning themselves as big online retailers, and they want to simply expand their portfolio by also selling recreational cannabis. So they're lobbying for online sales, of course. There should not be any mixture between consumption and sale.
Okay, so when you say cannabis, are you talking only about THC, or does Germany distinguish between CBD and THC products?
Yes, very much so. So I'm talking about THC, of course, but CBD is a different issue. Currently, under German, even now under German narcotics law, CBD is a cannabinoid without psychotropic effects. Is not perceived to be a narcotic. It is simply out of the narcotic sphere. But it's very hard to sell any products with CBD that don't have trace THC above the acceptable level or below the acceptable level. So, and there are other rules that prevent selling of CBD products, which are European food laws and so on. So there's a big discussion around CBD, but it's not part of this liberalization effort here. So this is THC. Yeah. So of course, as I said, there are different regimes, and it should still be a separate medical cannabis regime with different distribution chains, different qualities, different requirements on how it's sold, how it's labeled, and so on. And it's so the medical cannabis market should be retained. Also the German government wants to, because of the issue of importation for recreational purposes, which is not allowed under the UN convention, according to the German government lawyers, they say that they want to serve the recreational market solely by through German-based cultivators, which is in a way a bit strange because there's no banana growing in Germany for some reason, and there's also no kiwi in Germany, and cannabis is also a plant that needs a lot of light and a lot of warmth. But the German government wants to push this business. They're also energy intensive because you need really a lot of energy, and in these times it's a bit strange. But nevertheless, that's in their paper because they say it would be illegal to import for recreational purposes under the UN conventions. But it remains to be seen how this works because there's simply not enough capacity, and they expect a demand of 400 tons per year. And that can never be reached by building a German-based cannabis business, at least not in the next 5 to 10 years, particularly if you have all these safety features for the buildings. So what is unclear still, how can the demand be met? Which are the shops that will be licensed to sell? Do pharmacies play a role? Mail order business? And most importantly, the time schedule is not yet clear because of all these obstacles that are in the way. It seems to be the case that they want to push this now. The German health minister actually 2 days ago or last week gave an interview saying that he expects the draft law to be presented to the Bundestag in the second quarter of 2023. Everybody expected it to be a bit later, and it's very ambitious. And once it has gone through Parliament, of course, it needs to be presented to the European Commission for approval, and that can take at least 3 months. So liberalization, if you ask me, it will not be earlier than the second half of 2024. But it's also the latest point that it needs to be done because in 2025 we have the next general election, and they want to have this dealt with before the next election kicks in. So that's my summary for Germany. It's a very interesting time. A lot of people are now trying to invest. A lot of people are positioning themselves for the recreational market, which would be the biggest recreational market probably worldwide after the US. So we will have to see.
Is there a lot of recreational cannabis use in Germany now?
Yeah, on the illegal market, of course. Yeah, there is, yes.
And are any investors jumping into this, even though it's not yet formulated or legal, so that they can be in on the ground floor? We're seeing so much of that in the US, despite the legal risks.
Yeah, there are some people who are hesitant. Those who are companies that are still hesitant, and they also play a big role, of course, in the future, are the big, pharma, tobacco, beverage companies. They're all having plans, but they really go in once it's clear, because they're also looking for new opportunities. All the issues of edibles and things like that, beverages with the THC. also part of this key points paper, but a very, very small paragraph about this. They want to have more security because they're more conservative. All those companies that are now in the medical cannabis market are sort of like who have more of a startup mentality, and the investors are not so risk averse. So they are really getting in here and want to position themselves, because the likelihood that it comes is probably 2/3, or so 60 to 70%, maybe even more.
We have a few minutes left. Anybody have, and we've heard a little bit about Canada. Anything from any other parts of the world with big transitions in the cannabis operations? Anybody want to talk about expansion of recreational cannabis in their markets? All right. I had a thought for our next meeting. I would love to hear what other law firms around the world are doing for clients, not just about what the law is. Where are people focusing? Who's representing investors? Who's representing distributors? Who's representing growers? Who's helping the pharmaceutical companies? Who's helping the tobacco companies? And I think that would be useful because I had a research question today. We don't do the research side. I need to know where to send them. And it's a research involving Israel and the United States. And I'd like to be able to direct them to the right firms. Would that be a good topic for our next meeting? Would people find that useful? It's a little bit of an infomercial, but.
Yes, of course.
Okay.
I had one quick question for Victor, which is Canadian law pretty well settled now, or are you seeing any changes, particularly at the regulatory level?
It's a great question, actually. So the law, it has been settled for some time, but as I think I saw in Bjorn's slide as well, our law has a built-in review mechanism. So it was supposed to be reviewed after 3 years. Because of COVID, that has been delayed. So finally, earlier this year, which is now 4 years after our regime is in place, the government has initiated the mandated review of the law. And so participants are jumping in, obviously, to highlight all the inefficiencies and the issues to hopefully make it better. Because as anybody who follows the Canadian cannabis market on the capital market side will see, the valuations have tanked, right? The winners have emerged, and all the losers, for lack of a better term, have surfaced in terms of all the failures of the mid-market, smaller deals that are no longer able to access the market because there's just way too much capacity. People wildly overestimated the ability of the regulated market to displace the black market. I think based on recent research, the legal market on the recreational side has finally exceeded 50% of the overall recreational market in terms of supply of products. But after 3 years, the black market still has almost 50% of the recreational market. So it's been a challenge. But short answer, Evie, is our laws are now under review, and hopefully there will be improvements on both the sort of taxation side of things, on the marketing side of things, which are really barriers to sort of the success of the various producers to be able to combat the black market in terms of being able to market themselves appropriately, and number two, being able to cost themselves appropriately. So we'll see.
Other comments, thoughts for the good of the order? Other thoughts for future meetings? I don't want to have a meeting for the sake of a meeting. I'd like a goal. Can I ask everybody to think about it and share your thoughts with me and or Jorn, who co-chairs this practice? Evie and Jorn, thank you very much for your thoughtful presentation. I learned a lot, including about America.